And today we have with us in the studio President of Goa Mineral Ore Exporters Association, Sri Ambar Timblo. Ambar sir, welcome to the studio.
Thank you for having me.
First things first, very simple question: why are mining companies in the Supreme Court, and what's your plea? What do you expect?
The mining companies on the Supreme Court to enforce their right that their leases are valid till 2037. That's the specific prayer that is being sought by the mining companies. This comes from the fact that the last Supreme Court judgment said renewals cannot subsist in Goa, and therefore the only means acceptable and available right now to mining companies in Goa is to extend the leases. So it's a limited point there that the Goa government had said that in principle they agree with this, but as the Supreme Court order in the past has been passed, it's better to get it dealt with by the Supreme Court. So that's the reason the mining companies are on the Supreme Court, yes.
So, but how is Goa's case different from the rest of the country? Because even in the Supreme Court, repeatedly it has been seen why Goa should be looked upon from a different prism. Why?
Well, there are two parts. One is, I'll go to the historical aspect of Goa's mining and mining rights second. First, I'll just say that every other state in India, post the new amendment to the Mining Act in 2015, had the power to renew mining leases, and all their renewals were permitted to be done prior to that date. The Supreme Court, in its wisdom in 2018, held that, be that as it may, Goa did not have the right to renew, which means effectively Goa has been treated differently compared to any other state. That's as far as the laws persist today. Of course, the history of Goan mining leases is they were all made into mining leases in 1987, via an abolition act. Till that point in time, they were concessions as granted by the erstwhile Portuguese regime. So that makes it historically different. In other words, the mining leases that we're talking about in Goa were never actually granted under an Indian act. They were granted in concessions, and made leases by an Indian act in 1987. And that correlates to your first question, is that in 1987, if knowing that we were granted a mining lease then, the law specifies that it should be 50 years since then, and that is why when the Supreme Court to enforce that right.
When you look at it from the contribution point of view,
Yes.
how do you describe it, the contribution of Goa's mining industry in Goa's development?
More than just contributing directly, which it was the largest direct contributor to the economy, is that being over so many decades, generations of people evolve in their businesses and evolve in their ability to make business through a consistent industry. Goan mining has been there since the 1940s. And it's interesting that despite being in a different sovereignty, we moved to a different sovereignty, difficult circumstances from a market standpoint, from a geological standpoint, but the right to work and the right to mine never stopped. That stopped for the first time in 2012. None of us ever imagined 8 years down the line I'd still be having this conversation with you. And again, relating back to your first question, the matter before the Supreme Court has nothing to do with the environment. It has nothing to do with damage to ecology, etc. Because on most of those grounds, most of the mining companies, if not all the mining companies, have been found not having committed any of those violations. So the matter before the Supreme Court is only a legal interpretation as to how long does your mining lease continue, and eventually when will the concession matter be decided in the Supreme Court.
So, but the question arises, has the industry taken adequate measures post 2012, regulatory measures, so that what happened from 2007 to 2012 and what Supreme Court says is not repeated again?
That's a good question. I think since 2012, the systems that have been put in place, and especially in this present government, the systems that have been put in place, just to give you a small idea, when you exported a ton of ore prior to 2012, you had to ensure that you had about 5 to 6 various permissions to ensure that it was done with all compliances. Today alone, you have to do north of 35. So the level of compliance has gone up by over 500%. But the interesting thing is now we have all the best rules in the world. We have all our transportation routes on electronic systems. At no point in time can you not know which ore is leaving from which mine to which jetty. Only problem is there is not much transportation because there is no mining. So your operation is successful, you have done everything, but the patient still doesn't seem to have recovered.
Do you think mining companies have got unfair treatment during last 8 years?
Yes.
Why so? And how so?
Well, it's simple in the fact that despite 2014 attempts by the NGOs, etc., to say you have committed illegality, you have done, throughout all this process, we have succeeded. If you look at the judgments in other states, whether it's Karnataka or Orissa, you will see where the courts have gone with regard to companies that have committed illegalities. You haven't seen that here. But at the same time, as much as I can hold a great report card that I don't have anything against me, I am fine, etc., end result is mining is not still happening.
Then that brings me to the question of what state government proposed to the center, saying that look at the legislative cure. So
Yes.
that's the best and the fastest way to restart the industry.
Yes.
But nothing has moved ahead. So even after so many years, so many hearings, so many deliberations, are you happy as an industry with the efforts of the state government?
Well, if you see on the aspect of legislative cure, the attempts have been and the representations have been, and I have to say this, especially with the present government, the intent of those representations are not in doubt. At the same time, we have to appreciate that the central government cannot be perceived, even though very clearly we have submitted and tried to clarify that this legislation is required to correct an unfair, unjust situation. They also have to be very wary to ensure that there's not an allegation that you're doing a specific legislation for a specific state, even though that's not the case. But I think central government has had to look at it from all angles. And the central government themselves in the state have very clearly also in the Supreme Court made known the unfair treatment. And that is why the state government has also filed a review of the 2018 judgment, which I understand will be before the Supreme Court next week.
How fast can the industry restart if the Supreme Court rules favorably?
Well, there are two parts. Like I mentioned, there's a review before the Supreme Court, and I wouldn't want to comment on, obviously, if you ask me what I'd like, I would love to get two things. One, that the clarity for consistent and sustainable mining is clear. So as a president of the association, as well as a person from my company, our objective is to say we will attempt to start it at the soonest, after ensuring all compliances, as we've always done in the past, are in place. At the same time, what I think will give comfort is once we are sure that this is the way we can move forward, then it's only a question of when, not if.
Yeah.
So we need the answer to be when.
We need to
and not
transport
be
from
known
the if to when.
From if to when.
If to when.